Hello, my name is George Stafford and I'm the director of the European Implementation Network. We're a network of about 36 different members from all over Europe, civil society and individuals, dedicated to working on the implementation of judgments of the European Court of Human Rights. We have a small secretariat in Strasbourg, and we're the only NGO in Europe that specializes completely on this niche issue of implementation of judgments of the European Court. So today what I want to talk to you a little bit about is start by making the claim that the non-implementation of judgments of the European Court of Human Rights is one of the most important challenges to human rights on the continent. But it's also one of the biggest opportunities to improve the protection of human rights in Europe, and it's one of the biggest opportunities for national human rights institutions to improve human rights at the national level. So there's a huge issue to be addressed, but also a huge opportunity to advance protections of human rights at the national level. Before I explain why, I want to talk a little bit about what implementation means. And I'm going to start by doing that with an example. There's a mother and daughter in Moldova, and they're being repeatedly attacked by the child's father. There's huge delays in protecting them and a failure to prosecute the attacker. So despite numerous requests for a protection order from the mother, the authorities fail to provide one for a long period of time, and the same applies for the prosecution of the father. Mother and daughter are covered in bruises, as well as suffering from physical attacks. They suffer from emotional attacks and psychological abuse as well. They win their case at the European Court of Human Rights, and a systemic problem is identified. So what does implementation mean in this case? What's required is justice on two different levels. The first is for the applicants themselves. So that's protection from further violence, that's a criminal investigation in the case, and it's compensation. But there's also a deeper level of implementation, which has a much more widespread effect, and that's justice for society as a whole. So governments, when they receive a violation from the European Court of Human Rights, they're under an obligation to conduct reforms to prevent the same thing from happening to other people in the same society. And that's known as general measures. And this can include legislative changes, it can include practical changes. In this particular case, it requires improvement of protection orders, it requires greater preventative action on behalf of national authorities, it requires training for police and prosecutors so they can identify cases of domestic violence and act accordingly, and it means proper criminal justice for the offenders. So that's what implementation is all about. It's about protecting individuals and providing justice for them, but it's also about providing justice and preventing the same problem from happening again on a much wider scale. So I mentioned that that's the ideal scenario, but I also mentioned that implementation of ECHR judgments is one of the greatest challenges facing human rights protections in Europe. And I want to advance two reasons for that. The first is a problem of government inactivity, and the second is a problem of ineffective reforms, both of which national human rights institutions can have a huge impact on. And I'm going to address each of them in turn. Before I do so, I should note that this is very much focused on the second part of judgment implementation, the general measures, the things that are meant to affect the wider society. So first of all, the problem of inactivity. In many European countries, large numbers of judgments of the European Court of Human Rights are not being responded to with government action. And we can see this by looking at the statistics. First of all, a little definition: leading judgments are the subject of these statistics. And leading judgments are those that reveal a new structural or systemic problem in a country. So in the example I gave of domestic violence in Moldova, that's a leading judgment with other judgments which are repetitive, that identify the same issue, and identifies the structural issue of a failure to protect people from domestic violence in that country. Now, of the leading judgments, the judgments that identify widespread problems, of the leading judgments for the last 10 years, 43% are pending implementation. And the average length of time that leading judgments have been pending is now over 6 years. It's important to note that in lots of these cases, reforms might be ongoing, but there might also not be. And overall, I hope you'd agree that these kind of numbers are a source of concern when it comes to the European Convention system and the desire that it provides protection for all. Overall, there's over 1,200 leading judgments pending. as well. And you might say that this is a result of a few countries with particularly bad implementation records. Now, whilst it's true that there are some countries with particularly high numbers of unimplemented leading judgments, many countries in Europe suffer from this issue, and perhaps many you might not expect. And we can show this in a little bit more detail through a resource we created on the EIM website, which I'll bring up for you now. So this is a page of different countries that we've got on our website. And what you can see is all of the member states of the Council of Europe, and they're shaded in red depending on the proportion of leading judgments from the last 10 years they have pending implementation. I mentioned that overall, 43% of the leading judgments from the court made final over the last 10 years are still pending implementation. But this map can help you show which countries have particularly high proportions in that regard. It'll also help tell you the number overall of leading judgments for each country. And you can have that just by hovering over the different countries, different states. So for example, Poland has 28 leading judgments pending overall. 35% of its leading judgments for the last 10 years are pending implementation. Hungary, it's 75%, 53 leading judgments pending overall. And you can also identify in a little bit more detail these statistics by clicking on the country page itself. We have a dedicated page for each country, and they'll designate the statistics. On most countries, there'll also be an example of a case. So for example, this is Romania. Number of leading judgments pending implementation, 77. Average time those have been pending is over 4 years. And the percentage of leading cases for the last 10 years still pending is 46%. So that's one example of many. I encourage you to take a look at this map. It's under this part of our website, countries. That's einnetwork.org. And take a look at your own country and to see what the statistics are like rather for that state. It's important to bear in mind, of course, that there's no perfect way to represent implementation statistics. And I encourage you to read a little bit of the sort of the definition of our data at the bottom of this page and see how it correlates to your country. But nevertheless, we think this is a really helpful way to give an overview of the seriousness of the non-implementation problem. And also it helps actors at the national level in each state identify exactly how bad the problem is in their own country. So what can national human rights institutions do to address implementation inactivity on behalf of member states? There's a huge amount that national human rights institutions can do, but I want to focus two things. First of all, promote structural mechanisms to improve ECHR implementation, and you'll hear a little bit more about that in the first webinar from colleagues from Slovenia. And secondly, national human rights institutions can highlight the overall implementation record of their government, and I might discuss a little bit more about that in the second webinar. However, that's the first issue that I wanted to raise, the kind of levels of inactivity by governments in regards to implementing ECHR judgments. But I also wanted to highlight this second issue, which is sometimes ineffective implementation of ECHR judgments. And this issue is as follows. Even if governments are being active in responding to ECHR judgments, this activity has to be meaningful. For reforms to successfully implement a judgment, they need to properly address the issue which is highlighted in the violation. So, for example, I want to focus on the first bullet point of this slide, which is to say that in September of 2019, back to our Moldova example, the government made submissions to the Committee of Ministers of the Council of Europe to say, we've made lots of progress in this case. We think there's a bit more progress to be made, but ultimately the problem's being solved. You can close the case. Now, the interpretation of whether implementation is really happening in any case is always a subject of quite considerable difference of opinion, as you might expect. On behalf of governments, tend to be more optimistic when it comes to implementation and how things are going. And on the other hand, NGOs and national human rights institutions tend to be a bit more pessimistic. And we're a network of NGOs from across Europe, and in our experience, the NGOs, civil society, but also national human rights institutions are the ones who really know what's going on the ground and are able to test and and provide a contrary opinion to government submissions. So the submissions made by a local NGO in Moldova specializing in this issue of domestic violence, they highlighted the fact that there were still very low rates of prosecution, very low sanctions for offenders, very little support for victims, and they did it with hard evidence and concrete statistics. And they even made the argument that some solutions being put forward by the government were making the problem worse. A particular problem was the low level of prosecution rates in comparison to a high number of complaints about domestic violence. And what they were able to do was identify the fact that essentially the government hadn't resolved the problem, lots more action was needed. And fortunately, following that submission, the Committee of Ministers of the Council of Europe kept the case open, kept monitoring the implementation of the case, and included recommendations of the NGO in its decision, in its requests for activity from the government. So I think what I hope that example shows is how it is quite common for governments to try and identify or claim that problems are being resolved. And it's really the responsibility of people on the ground, such as national human rights institutions and NGOs, to counter government claims, which are sometimes quite optimistic. Now, the consequences of ineffective implementation of ECHR judgments in this sense can be twofold. In some cases, they can just remain pending at the Committee of Ministers with no progress. But the worst case scenario is the second listed there, which is premature case closure. And of course, that's a kind of disastrous scenario for those who want to protect human rights, because it means that the issue which we're trying to resolve is no longer has the attention of international organisation. How widespread is this problem of ineffective implementation of judgments? According to our members and partners across Europe, it is a very widespread issue. We see time and time again how NGO and national human rights institution involvement in the judgment implementation process is really important for telling a different side of the story and showing that government reforms to date have not yet been effective. But even though it's very important and there's lots of cases like the one I just referred to, overall, our research indicates that only around 7% of leading cases are subject to monitoring efforts by NGOs and national human rights institutions. So I think what that indicates to us is that although it's really, really key that this other side of the story is being told, in most of the cases it's not being told. And that is a recipe for ineffective implementation of ECHR judgments. What can national human rights institutions do to address this problem? Two things. First, engage in dialogue with government about ongoing reforms at the national level. Second, make submissions to the Committee of Ministers and the Department of Executive Judgments and the Council of Europe implementation monitoring process. And we'll be talking a lot more about these different things in the third and fourth webinars, and indeed the second, I should say. So I think that's about all I want to outline at the moment. There's one more thing I wanted to address before I finish, which is just to say the following. I hope from the things I've outlined today, you'll agree that the implementation of ECHR judgments is a really big issue and one that really needs a lot of attention. Now, we hope that national human rights institutions can play a really big role in addressing it, because we feel that they have the expertise, the resources, the passion to really make a difference. And if it is one of the most serious systemic problems facing human rights in Europe today, then it needs one of the most systemically operating actors, one of the best resourced actors, and the actors that have the most expertise. National human rights institutions have a huge role to play in that regard. However, at the moment, there isn't a huge amount of work being done by national human rights institutions compared to civil society on the implementation of judgments. And that's indicated a little bit by statistics raised by Nikos in his video. So we really hope that this series of webinars can be a jump start to help national human rights institutions get more informed about how they can act, and to provide a liaison with us about how that can happen. And we really look forward to engaging with you all about that over the next few weeks.